Good morning, Dr. Sanshu. We are Group E, and the topic our group has chosen is the Immoral, Irreligious, Seditious, and Obscene Works in Copyright Act 1987. So before we get started, I may introduce me and my group member first. My name is Tan Kai Yi. My matrix number is 270907. So far, we have separated our discussion into 6 sections, which is introductions, immoral works, irreligious works, seditious works, optional works, and also conclusions. So we have provide each of every sections a cases and the provision related. In the introductions, I defined the Copyright Act 1987, the acts that provide the copyright in Malaysia, and it defines the essence of copyright eligible works and the extent of protections and also the manner in which the protection is granted. The copyright owner, who is the person who is granted the copyright, is especially have the broad rights of their works, and this right can be used in several beneficial ways. It means that they can prevent from others to use reproducing their works unless approved by them. So in order to copyright something, we need to fulfill 3 elements, which is the fixations, originality, and also the expressions. So the fixation means that a creative idea must be locked in a permanent way, and the originality is that in order to copyright the works, the, the, the works must reach a degree of originality by the author. And the expression is due to the idea cannot be copyrighted, so it must have the expression of the work in order to get the copyright. So the duration of validity of copyright is actually based on the factors such as the precise nature of the content on which the copyright exists, the identity of the copyright owner, or whether the works was jointly ordered or anonymously customized. So after all, in this presentation, we are going to present about the 4 categories of literary way, where are the immoral works, irreligious works, seditious works, and optional works according to Copyright Act 1987.
Good afternoon and Assalamualaikum. My name is Nur Fitra, and I'm here to present about the copyrightability of immoral works. Okay, so I'm going to talk to you about the history of the copyrightability of immoral works, because back then the courts used to have a different approach to how they would allow for the copyrightability of immoral works compared to now. So back then, the courts used to have a different approach to the copyrightability of immoral works because they would deem that these works to be uncopyrightable. During the 18th and 19th centuries, the English courts ruled that immoral works would be exempted from copyright because it was widely believed that it was the court's duty to be a conservator of the public morality. And this doctrine is known as the civil obscenity doctrine, where an obscene work would not be protected by copyright, and it can be treated as if it were in the public domain. So in the case of Walcott and Walker, the judge, Lord Eldon, had said in his ruling, in this case, that where a work was of an immoral, obscene, blasphemous, libelous, or seditious nature, the author of the work is not allowed to maintain an action of law. So now, compared to the law of back then and now, during the 20th century, the courts took a more liberal approach in how they determine the copyrightability of an immoral work. For example, in the United States, the Copyright Act 1941 was amended in 1974. And in the 1974 Act, it was stated that the examiners of the copyright are instructed to limit their determination to statutory formalities without taking into consideration the literary or artistic merits of a work against the immorality or obscenity of the material. This means that the examiners of the copyright do not have to determine whether a work is immoral or not to grant the work its copyright, as long as it fulfills all the requirements needed in the Copyright Act. So, we have two cases that shows the differences in how the courts used to approach these cases in the immoral works. So in the case of Stockdale and Unwind, the plaintiff, Harriet Wilson, published her memoir titled Memoir of Harriet Wilson, which is an autobiography about the exploitation of a notorious courtesan. The defendant, Unwind, had parodied her memoir, so she filed for copyright infringement against him. But the court said that because the content in her autobiography contained some highly indecent materials, so the publication of the book actually breached English law of obscenity. So in the end, she was not able to claim for copyright infringement for the book. But in the case of Mitchell Brothers Film Group and Cinema Adult Theatre, this when the court started to use a different approach to determine the copyrightability of an immoral work. Because in this case, the defendant had owned a movie theater and he had obtained and showed the plaintiff's adult motion picture at his theater without the plaintiff's permission. So the plaintiff had a copyright for this adult motion picture, which was issued to him by the Copyright Act 1909. So the plaintiff claimed for copyright infringement against the defendant, but in the district court, the defendant was successfully able to assert the claim that the plaintiffs were not able to do relief for copyright infringement on the ground that the movie was obscene. But on appeal, the court held that it was improper for the assertion of obscenity to be allowed as an affirmative defense to a copyright infringement claim on several reasons. And the reason first reason is because the court could not find anywhere in the Copyright Act 1909 where it stated that obscene materials would not be able to be copyrighted. The second reason is because the Act was constitutional under the necessary and proper clause, even though it gives protection to works that arguably do not promote science and useful arts provided under the Copyright clause. And finally, the third reason is because it was held that the equitable doctrine of unclean hands was improper to be applied in this case because it contravened with the Act's property purposes. So you can see how different the court's approaches used to be compared to the court's approach now in relating to the copyrightability of immoral work. So I'll pass the floor to my friend. It's about irreligious works. Thank you.
A very good day I bid to everyone. I am Divagara Naidu, anak lelaki Paskaran, and my matrix number is 273777. So today I will be explaining about the position of irreligious works under the purview of the copyright law, especially in Malaysia. The word irreligious can be defined as something which contradicts or which goes against the basic teachings of religion all over the world. And it could be said that it questions the nature of religion all over the world. In Malaysia, there are no particular provisions which prohibits any matters which is irreligious in character. And to further understand, we shall look into several other legislations other than the Copyright Act 1987. First of all, under the Federal Constitution, Article 11 guarantees the freedom to religion. And some interpretation mentions that this freedom extends to the right of a person to not particularly profess to a religion or a belief. Therefore, it is not compulsory for a person to possess a religion. Although some might argue that under the Rukun Negara, the first pillar which states that we have to believe in God, or particularly in bahasa Melayu, kepercayaan kepada Tuhan. However, legal experts claims that this does not dictate that the Rukun Negara is legally binding, thus requiring a person in Malaysia to profess to a religion. However, there are several exceptions, especially which applies to Muslims in Malaysia. For example, Muslims who practices or propagates false doctrines, which is against Islamic teachings, can be penalized under Section 3 of the Sharia Criminal Offences Federal Territories Act 1997. So if a person is found to be propagating or spreading false beliefs that questions the nature of the Islamic teachings, religious departments can take action against those people by seizing materials and confiscating any works which is irreligious to Islam by taking them away and keeping it in custody. There are not much cases which discusses about the position of irreligious work under the copyright law. However, one notable case for us to take note is the case of Lawrence and Smith. In this case, the defendant, publisher, made unauthorized copies of a lecture made by a plaintiff who is a lecturer, which is titled Lectures on Physiology, Zoology, and the Natural History of Man. The plaintiff filed for a claim which says that there was a copyright infringement since the defendant made unauthorized copy without asking for consent from the plaintiff. However, the defendant in his contention claimed that the work done by the plaintiff is irreligious since the work questions the immateriality and the immortality of the soul, which is quite contrary to the teachings of the scriptures. Thus, the work should be ineligible for copyright protection. Note that in the medieval ages, there are several laws which prohibits anything which is irreligious in nature, and the punishment for those who are irreligious or those who spread false doctrines which condones irreligious teachings will be punished severely. However, it was held in the court that even though the work is sacrilegious and liable for punishment under the blasphemy law available then, the duty of the court at the hearing is to consider the merits of the case based on its civil nature. Thus, the work should be eligible for copyright protection. Now let's talk about the position of irreligious work in Malaysia. Since there is no particular provision, especially under the Copyright Act 1987, which prohibits or denies the right for an irreligious work to be granted copyright protection, therefore, we can conclude that any irreligious work that is published within Malaysia and complies all the other elements which should make it eligible for copyright protection should be granted copyright protection in Malaysia. So that's it for today. I will pass it to the next presenter.
Hi, my name is Nushara Najwa binti Zaini. My metric number 273390. And on my part, I'm going to present about seditious work. Seditious work is any publication of work that have an immoral content that is contrary to public policy. The Copyright Act did not mention anything about seditious work. However, in Malaysia, the Sedition Act 1948 has been legislated to subject um, any work that has been published with any seditious content. According to Section 2 of the Sedition Act 1948, which states that any act, seditious is any act, speech, work, or publication that has some sort of seditious tendency. While seditious tendency is a tendency of bringing hatred towards the authority or the government of Malaysia, uh, including disaffection, ill will, and questioning the provisions that are protected by the federal constitution, which are the Article 152, 153, and 181. Section the an example of seditious publication is like posting an article that critiques the government who refuse to give the rights of citizenship to certain people. The posting also intends to overthrow the government uh, and an attempt to persuade other people by joining hands to oppose the current government. This criminal action is an offence that is subject to to the offences under Section 4 of the Sedition Act 1948, which states that if any person commits this offence, the sanctions that will be imposed is fine which may not exceed 5,000 ringgit or imprisonment not exceeding 3 years, or the accused may be punished with both sanctions. Meanwhile, if a person has possession of any seditious publication, he may also be fined not exceeding 2,000 ringgit and imprisonment not exceeding 18 months. The publication also may be forfeited and destroyed. Section 5 also states that if a person has been alleged under this offence, he may be prosecuted with a letter of consent of the public prosecutor, which the proceeding may be heard in any court in Malaysia as a trial court. Therefore, to conclude, to be held liable for this offence, the publication must be proven by the public prosecutor that the accused was intended to bring hatred to the government in any way. This can be seen in the case Saudi against Sherwood, where Lord Eldon states that the publication of Wade Taylor cannot be ordered for injunction. This is because the court thinks that the character of the publication is innocent in nature. The accused did not intend to bring hatred to the government in any way, and the publication may actually be protected by the court. In another case in Malaysia is of seditious case of Melan bin Abdullah and another against public prosecutor. The accused of this case actually has been alleged by publishing a newspaper that contained a seditious report, which has been charged under Section 3 of as publishing work that has a seditious tendency. Okay, this happens on April 6, 1971, when the newspaper company has published a report in the newspaper that contained a seditious heading of a speech given by a Malay leader. However, the header of the report being seditious, which states that abolish Tamil or Chinese medium school in this country. This heading attract the sensitive issues under Article 152, which has been declared as protected by the federal constitution, which this article states about the privileges of races in Malaysia. Right. The issue of this case is whether the accused has taken all precautionary steps before publishing the report in the newspaper. This case has been appealed to the court on the claim that the first appellant has taken all precautionary steps before giving the subordinate, who is the second appellant, the power to publish any publication. The first appellant in this case is the chief editor, who has the power to supervise the subordinate before they publishing any works in the newspaper. Meanwhile, the second appellant is the person who has published the report with a seditious heading. The first appellant argued that before he gave the authority to the subordinate, he has conducted a seminar to guide the employee about the sensitive issues that cannot be published and any related law based on his understanding. The public prosecutor claimed that the offences under Section 4 has implied a strict and absolute liability for the accused, while the first appellant has a strict and absolute liability where he lacks due care because he has a veto power to supervise the article and dismiss any employee that has misconduct with the law. The public prosecutor also added that there is no reason for the first appellant to use defense where he did not know where there is a possible seditious tendency, and he in fact has responsible for negligence on his part. However, the court held that there is no negligence on the part of the first appellant because he has a sufficient due care and precautionary measure, while and the conviction of the first appellant must be set aside. Meanwhile, there is no suitable defense for the second appellant to publish the report by using that word because there is a degree of distinctiveness between hypothesis and statement of fact. Then the second appellant should be convicted and must be liable for the responsibility. And in conclusion, Malaysia has implied the freedom of speech in Article 10 of the Federal Constitution. However, our country also has imposed the limitation of freedom to express in any publication and also in any form of works. A clear definition between criticism and sedition must be declared to avoid any possible issues of seditious tendency as prescribed in Section 3. Even though the Copyright Act did not mention anything about seditious work or publication, the Sedition Act 1948 has laid down all terms, interpretation, offences, and even punishment of seditious work. Therefore, author must know that in any way to avoid any attempt of spreading hatred or disaffection towards the authority. Thank you.
Assalamualaikum. My name is Naziha. I'm going to present about the obscene words under Copyright Act. So, firstly, we should know what is obscene words. So, according to the legal dictionary, it's defined obscenity as the character or quality of an act, utterance of item tending to corrupt the public morals by its indecency or rudeness. Obscenity is a legal term that applies to anything offensive to morals and is often equated with the term pornography. So in short, obscenity refers and is synonymous to the pornography. So, next, according to Jenkins in Britannica, obscenity is defined as any or particularly pornographic content as offensive to the sense of decency of the public. However, a truly satisfactory description of obscenity remains elusive, mainly due to what is deemed obscene is always in the eye of the beholder considered beauty. So next, we're gonna look at a case, an Indian case of D. Panduragan and another and state. So this case, the learned judges has defined obscenity as an offences to chastity or modesty, oppressing or presenting to the mind or view something that delicacy, purity, and decency forbid to be expressed, impure as obscene language, obscene pictures, anything that expressing or suggesting unchaste and lustful idea, impure, indecent. So in conclusion, obscenities is against the public morality and it also is synonymous to the meaning of pornography. So next, I'm going to present about the provisions in Malaysia concerning obscene words. So for your information, in Malaysia's Copyright Act does not mention anything about the obscene words. However, regarding obscene words, there are a few of the statutes in Malaysia that regulating these words. For example, under the Communication and Multimedia Act 1998, as the section 211 plus 2 stated that a person who provide obscene content commits an offence and shall be liable to a fine not exceeding 50,000 ringgit or to imprisonment not exceeding 1 year or to both. So, thanks. Meanwhile, under the Penal Code, under the section 292, it stated that anyone involved with obscene publications, either by selling, hearing, exporting, importing, or taking part, shall be liable for imprisonment for a term which may extend to 3 years or with fine or with both. However, there are exceptions under the Penal Code that it does not extend to any book, pamphlet, writing, drawing, or painting, kept or used bona fide for religious purposes or any religious sculpture, engraved, painted, or otherwise represented on or in any temple. So in conclusion, obscene words in Malaysia is prohibited. However, there are exceptions under the penal codes that in the purposes of any religious matter, obscene words is allowed. However, it's still under the Copyright Act is still silence regarding obscene words. So we assume that obscene words can be protected under the Copyright Act. So the word obscene is not defined in any penal codes or any statutes in Malaysia. We have the provisions regarding obscene words in Malaysia. However, the words obscene is not defined as according to Amar and Nazli in 2019. Obscene at present may not be in the future as it can be differs and changes from age to age, region to region, perhaps from region to region. So next, I'm going to present this case of Australian case that is Venus Adult Shots Pty Ltd and Francis Site Holdings Ltd 2006. So in this case, the respondent, which is the Francis Site Holdings and others, they instituted civil proceedings in the Australian Federal Magistrates Court against the appellant, which is Venus Adult Shops, and other appellants, alleging that the appellant companies have made and authorized the making of copies of private films, which refer to the adult pornography films, without any license. So the respondent also alleged that the appellant had sold and offered for sale counterfeit copies of the adult films, and that they knew or should have reasonably known that there was an infringement of copyright in the making of the copies. So in that case, the court held in the favor of the respondent, where the court held that copyright also protected the obscene words. So his Honor said that although the words were so grossly immoral or pornography, so which refer to obscene words, they should not lose the protection under the Copyright Act. So it does not seem to have been any argument presented in the pleadings that adult film should be refused copyright rights on ground of their immorality or pornographic existence. Therefore, the respondent words are entitled to copyright protection, since copyright may subsist without abstention in all original literary, dramatic, and aesthetic words under the Copyright Act. So in conclusion, obscene words is protected under Copyright Act even though it is silent. So that's all from me. I will pass the floor for Kai to conclude this presentation.
So after all, in conclusion, we have known that the rationale of copyright is to encourage the progress in the art and science for the benefits for the public, and also to ensure the to secure the fair return for copyright creators of work, so as to ensure the continued copyright credibility. So according to the review, we have known that the copyright law does not specifically enforce a limitation based on the content for copyrightability of works. So it's entitled to the rights and the protections of copyright and to subsist regardless the content, as long as the original and fixed works are in the tangible medium of expressions. Therefore, the immoral, the seditious, irreligious, and obscene works is said to protected under the copyright. So, in conclusion, the the Copyright Act is, however, failed to provide the provision regarding the works of immoral, seditious, irreligious, and the obscene works. So, the best way to ensuring the interest of the owner is to compromise the issue and make amendment of the defect of Copyright Act 1987 in order to bring a new hope to the owner to foster the innovation of their creative work. Thank you. Thank you.